I just want to add that one of the things that was really important for to have Yugoslav lawyers participate and help be on the defense teams was their knowledge of their country and the wars and that sort of thing. That most of the international lawyers didn't have that, and neither did most of the judges, I have to say. So that put them at a disadvantage, and which could have pretty serious repercussions, I think. So that was, you know, a drawback. And I have to say that, I mean, I can't really evaluate sort of overall because I was looking at a narrow case, but I did check in on a few other cases now and then. And there were some excellent defense attorneys, and there were some that, international, were not so great. So I think the other thing is that it was very difficult for defense counsel because they didn't have the same resources that the prosecution had. And you know, they
not even a lounge.
Yeah, I mean, they didn't even have a lounge. They have to sort of hang out in the lobby or something.
On a computer when I was there.
Yeah, yeah. And it took them. They organized, and were you know, they formed an association, and they were able to lobby for increased resources. But they were at a disadvantage, and
they were also having trouble figuring out what the rulings were that really necessarily didn't rise to the level of published rulings. You know, they weren't the benefit of having an association that actually is monitoring what's going on in every trial and the rulings and what the judges are doing, and they just were at a huge disadvantage. That they did finally organize.
Yeah. The other thing is that, you know, there's a rule, we have the same rule here, that, you know, the prosecution needs to disclose any potentially exculpatory evidence. Well, there often was, and certainly there was in the Milosevic trial, they erred on the side, and I think justly so, of you know, disclosing much more than withholding. And so there were millions of pages, and that was, now I don't have as much sympathy for Milosevic because he didn't choose to have legitimate counsel, though I have to say he did have a defense team that operated in the background. And the other piece of it is that those who, you know, the accused did pretty much know what went on, especially at the leadership level. So they had that information that the prosecution needed to learn. But nevertheless, there was a difference in resources, and I think that the court, as well as certainly the defense bar, really pushed to have that changed. And I hope that it's become more equal now. It's been a while since I've been there.
Yeah, if I could add, the rules, I thought, when I was there, incidentally, the rules at the ICTY, unlike the rules at the ICC or unlike the rules back here in our American courts, were made up and changed like 30 times over the course of a couple of, by the judges themselves. Now the ICC requires the state parties association to okay any changes. And as you know, back in our own federal courts, the federal rules process goes through special appointed committee by the Supreme Court, and lies before Congress, et cetera. So the court can do some local rulemaking, but basically, but here, you know, they can change their rules and, you know, sort of send them, so that you have seen changes in the rules over time, actually tending a little bit more toward adopting, in my view, more civil law processes. It started out, I'm told, with the American representatives having a draft prepared by the Justice Department, walking into the first meeting and getting most of it adopted. But as practice went on, you know, other judges from other countries, which far outnumbered the one American judge on the tribunal, would decide that they liked some things better, or things would come up in the court process that showed the deficiencies in those. But my basic point is, my impression, I'm interested in yours, Judith, would be that the rules were, if anything, pro-defense. The discovery rules were far more liberal for the defense than the ones that I was used to working with when I was here in the American federal courts. And so I'd say that the only place that maybe it wasn't was in this whole debate that goes on between the civil and the common law system of how much you can use written statements in lieu of live testimony. There they went more for the written than we did.
Yeah, it's true. Well, when you have these huge complex cases, Milosevic case being very huge and very complex, covering 3 wars over a 10-year period, and 66 counts, numerous fact situations in different crime sites. It's very difficult to, I don't know what I was going to say there, but it's difficult to hone down your evidence, you know, to what kind of evidence, how can you prove that? How can you prove this huge case? Well, one of the things that was useful was a procedure, a rule called 92 bis, and that allowed the prosecution, well, the court and the prosecution worked this out. For each of the crime sites that the prosecution ultimately went with, the court said you can have 4 to 5 witnesses, and you know, 1 to 2 of those can be live witnesses. The others need to be in writing, so they would have a written statement, and that was to save time. And you know, it was repetitive testimony, but it was corroborative. Well, the court also, you know, because it was very conscious of the defendant's rights, I think, and did bend over backwards to see that the defendant, especially a self-represented accused, had all of the assistance that he could. They allowed Milosevic, on these witnesses who did not appear in court, they allowed Milosevic to cross-examine them. So it didn't save as much time as they'd hoped. So for every, it was a, I'm kind of going into what we were going to discuss later, but I might as well, since it's here.
But they were also limiting overall the number of days, right?
They limited the number of days, right.
On both sides.
On both sides. But what caused the problem then is that Milosevic was not, he didn't pay any attention to the time limit. So the court would say, you've got 45 minutes to cross-examine this witness. 45 minutes of irrelevant cross-examination that didn't deal with the really important piece that that witness had come to say. And so the court would, you know, warn him and warn him and warn him, and then they would extend his time. Yeah. And that happened.
They were pretty lenient.
Yeah, they were pretty lenient.
You said so in your book, but I agree with you.
Thank you. Yeah, so that also was not a, I mean, it extended the time. So some of the time-saving pieces didn't save the time that they'd hoped.
Well, and talk about, because I wanted Natacha to talk a little more about the victims in the DRC, but talk about the 92 bis and the lack of then opportunity for victims to actually.
It was really difficult for victims that who went through the 92 bis process. So they had given their statements, their written statements, and they'd signed them out of court. They'd sworn to them, and they were brought to court to authenticate them, but also to be cross-examined by Milosevic. And that was how their story was told in court, through that cross-examination. The prosecutor would read a summary, very brief summary, a minute and a half, a couple of minutes, and then the questions were asked. And they often had, you know, they may have had nothing to do with the person's story. It's really concern for victim witnesses. So Milosevic is asking them about NATO. They know nothing about NATO. You know, did NATO bomb this? Did they not? You know, they know that, you know, their family was shot at close range, and that they were driven out of their village. So it was really frustrating for them to not be able to tell their stories. And there were more than one that said at the end of their testimony, "Don't you want to hear what happened to me?" You know, and so, you know, those were drawbacks of the.
That was one of the deficiencies, I think, Milosevic, and maybe it showed up in other cases. I don't think that written statement thing, although we adopted 92 bis while I was there, had gone that far when I was there, because as Judith pointed out, what is happening is normally the witness comes on, say the prosecution witness, gives the story of his or her victimization and what happened to her, and usually the cross-examination has to be relevant to, at least in the U.S. and even to a degree when I was there in the court, has to be relevant to what was on in cross. You couldn't bring in that was on in direct. You couldn't bring in something that was like totally unrelated to it. But I think in the process of 92 bis, and I think especially after reading your book and the way the court liberally interpreted it, I mean, the difference that appears between reading a statement and actually hearing a witness talk about something is enormous in terms of, I know as a judge, in terms of its influence on the judge. And when you heard the prosecution's evidence just in the form of this written statement, which you were probably late at night reading the night before anyway and you were tired, and then compared with comes dynamic personality, Milosevic to witness who doesn't seem to know what end is up in terms of the questioning. The whole sort of, we never know how the case would have come out, but the whole psychological impact, certainly for the media and other people, is completely distorted. I hope that's one of the lessons they may learn about applying 92 bis or its counterpart, if there is one in the ICC, about. That was always a problem with me. I had a great deal of difficulty adjusting to letting stuff come in, so much stuff come in and written, even having grown up in a hearsay rule, even though our hearsay rule is full of holes, but still there is a kind of a basic, and a basic notion that unless there's some reason not to, you should have a live witness. And I remember people saying to me, judges over there, they said, well, you know why you have that rule in your Anglo-Saxon? It's because you have juries, and juries cannot be trusted, to really read or understand what's in a written statement. They have to have somebody actually talking to them. But in our system, we only have judges. And of course, the judges are so up there and so clearly superior to your ordinary lay people that, we don't need that. I used to keep saying to the one or two that I talked to about this, but I don't feel that at all. I mean, I don't feel at all that I can look at somebody's statement and decide in that statement if they're telling the truth, or if they're not, which parts are true and which are not. But that is one of those fundamental differences which I think is important between civil law systems and common law systems. And when you try to mix them, such as 92 bis does, it doesn't always come out exactly right. It needs to be worked through.